At the Chamber, we also have our own special announcement to make. Over the past several months, we've heard from many of our members who are very interested in intellectual property. And today we are announcing our Intellectual Property Council. This is an initiative that's founded by the Chamber of Digital Commerce. All of our members have the ability to participate in this initiative with us. And its mission is to foster innovation in the blockchain industry and provide a platform for shareholders to collaborate and build an industry-wide intellectual property process. We have about 40 different members so far at the Chamber who have already signed up and who want to participate in this, including Blockstream, Block, Civic, Cognizant, Deloitte, the Digital Currency Group, Jim, Medici Ventures, Microsoft, T0, TMX, and Whipley, to name a few. And we have three experts that will be serving as the co-chairs of this group. And they are Patrick Merck, who is a fellow at the Berkman Klein Center at Harvard University. He's also counsel at Cooley. James Murdoch, who is the general counsel of Blockstream, will also be joining as a co-chair of this group. And Mark Kaufman from Rimmen Law, he's a partner there. They will be helping put this effort together and really guiding us in the direction in terms of the scope, the deliverables, and starting to address IP from a multi-stakeholder process. We also have academic institutions that will be participating in this, other standard-setting bodies and nonprofit organizations. So we're really opening this up to allow full collaboration to create that dichotomy and that balance between how do we protect intellectual property assets but still allow for innovation to thrive. So up next, we're going to have a panel, and all of our co-chairs will be joining us for this. We're also hosting the kickoff meeting to the Blockchain Intellectual Property Council. So for those who want to join, that's going to be on March 30th. And it's at noon, and there'll be a dial-in if you want to join. And if you email Dan at digitalchamber.org, we'll get you signed up. This is our next panel. It's going to be moderated by Mark Kaufman. And he is joined by Paul Keller. He's a partner at Norton Rose Fulbright. And also want to thank Norton Rose Fulbright for also sponsoring this panel today. We also have to his left, Patrick Merck and James Murdoch. So Mark, over to you.
Thank you, Perry Ann. I'm certainly excited to be working with James and Patrick on the Blockchain IP Council and with many of you, I hope. I'll let them tell you a little bit about themselves in a moment, but first I want to tee things up a bit. I don't have to tell anybody in this room about the tremendous innovation that's been going on within the blockchain ecosystem. And there's a movement, of course, towards standardization and open source. We heard David Treat talk about one of, I think it was 5 pillars, and one of those was standardization and interoperability. If you take a look at the distributed magazine that was in your swag bag, there's an article on page 66 entitled "The Race for Blockchain Standardization." So there's this strong culture of standardization and open source, and that's a very good thing for the ecosystem. However, there's something out there that could bring this innovation to a halt, and maybe that's a bit of an exaggeration for drama, but certainly the proverbial chilling effect could happen, and that's the emerging patent risk. We're seeing everything from large banks down to startups and everybody in between filing a lot of patent applications relating to various aspects of the blockchain ecosystem, from mining to consensus algorithms to various verticals. And this could be a problem if these parties decide to assert their patent rights. Now, certainly patents can be a good thing by rewarding innovators, but we have to strike some kind of balance, as Perry Ann mentioned. And the industry must find that balance between the proprietary rights of the patent owners and freedom to operate, so that the risk of entering the ecosystem won't be too great for some of the players to take. And I think collaboration between the industry players, much like we anticipate will come from the Blockchain IP Council, is the only way to solve that problem. So again, I'm excited to be part of this. This may be the first time that many of you our hearing of this issue or really focusing on it, but we have 3 panelists here who've been focusing on this for quite some time. And I'll let you guys tell a little bit about yourself before we get into a discussion. Paul, you want to start?
Thank you, Mark, and thank you to the Chamber. My name is Paul Keller. I head up the IP disputes practice of Norton Rose Fulbright in New York City. I've been in the IP litigation space for nearly 2 decades. A significant amount of that has been in the fintech area. As we heard one of our previous speakers talk about the chimpanzee making trades back when electronic checks were first processed, when futures exchanges first used electronic processing for their pit trading. I was there kind of at those front lines and have now seen this nascent industry begin to really take shape and just about to take the tipping point. A lot of discussion about innovation, a lot of discussion now about about open source and the implications there has led us at Norton Rose to have a number of conversations, both nationally and internationally, to begin to discuss the stakeholders in this field about how best to kind of approach it, how they're approaching it. And I look forward to sharing some of that insight with you today.
Thanks. My name is Patrick Merck. As Perry Ann mentioned, I'm a fellow at the Berkman Klein Center for Internet and Society at Harvard University. I'm also special counsel at Cooley. I've been in the blockchain space for, geez, this is going to be scary, like, what, 7 years now? Almost 8 years. Can you believe it? It actually has been a space that long. I've been described as the first Bitcoin lawyer, and I don't know if that's like a good thing or a bad thing, but I think we're still figuring it out. I have been a lawyer in private practice. I've been an entrepreneur. I've been a founder of fintech startups. I've been an early employee of them. I've sort of done a little bit of everything. I was a co-founder of the Bitcoin Foundation, where I served as general counsel in the early days and led the early public policy initiatives here in DC around Bitcoin and the blockchain, coordinated the first US Senate hearings on the issue and testified there. I was then executive director of the Bitcoin Foundation, and I've started a number of other companies as well. I spent a lot of time thinking about the IP landscape, and there was a small community of us, even way back in the early days of Bitcoin, who saw the potential threat of people patenting what would be obvious to people who are actually working on Bitcoin or in the blockchain, but maybe not obvious to a patent examiner who's researching or looking at it. People filing patents, getting patents, and asserting them over true innovators in the space, and how we could group together and try and protect this sense and this community of permissionless innovation that was happening in this new financial system. That small group has slowly grown. And I'm very happy that today we've grown to such a point that we're actually getting the right stakeholders together in the room to have a fruitful conversation about how we can create the proper framework to foster that sense of permissionless innovation as we move forward.
Good morning, everyone. My name is James Murdoch. I'm Chief Business Officer and General Counsel at Blockstream. I've been in sort of the high-tech space as either a lawyer or business development person for about the last 16 plus years. I was in private practice in Palo Alto. I then joined Google. I was at Google for about 6 years, Mozilla. My first real exposure to patents and open source came at Google. I then took that to Mozilla for a few years, and then have been in the startup scene for about the last 3 or 4 years. I'm probably one of the newer people on this stage to the Bitcoin space. I sort of would track myself at about 2.5 years at this point. And one of the first things I did when I joined Blockstream was started working on a defensive patent strategy for the company. It wasn't my idea. It was something that was very important to the founding members of the company that in fact, it was part of their employment contract that we set up a defensive patent strategy. And so that was one of the first orders of business that I had when I joined Blockstream. So I'm happy to be here talking about this important issue today.
Great, thanks. So let me let you kick it off, Patrick. As everybody knows, much of the fundamental software, Bitcoin blockchain and Hyperledger is open sourced. It's free for anybody to use. So why should we be concerned about intellectual property?
Yeah, so usually when we're talking about open source, we're talking about things like the MIT license or GPL. They don't always necessarily include patent rights in the grant. There's this common misconception that sometimes persists out in the market that says, well, I put this code out there, I license it under the MIT license, anybody can use it for free. That is true in terms of copyright. You have a license under copyright, but it says nothing about potential patents, right, that might be lingering out there because patents aren't related to the code in the same way that copyright is, right? Patents are a monopoly over an idea, not an expression of idea in the code itself. Now, there's always the challenge, and there's definitely a strong community of people who believe that there shouldn't be patents when it comes to software, and I can understand that to some degree, but it's also not reality, right? And the reality is that software is patentable, and it's something that we do have to think about. And just slapping the MIT license or GPL license, or even sometimes the Apache license, which does contemplate this to some degree, right, is not enough to necessarily protect you and your use and to give assurance to people who want to use your platform that somebody with a patent over the idea won't later come in and file litigation against you.
Right. Yeah, so Paul, you're in the trenches of all this as a patent litigator. Do you have anything to add to that?
You're spot on. I mean, there are a number of layers to this onion that make it just increasingly complex as you begin to scroll down, as you begin to move the players along. I mean, the open source concept, absolutely right, that there are a lot of different licenses that give you a lot of different rights. It's great to be in a community that has kind of like minds and uses a particular open source to do a particular thing. That doesn't mean, though, that people within the space, parties within that space, can decide to do things that are off the open source track, or parties that are completely out of your community and do a similar thing. The concept, now I know you said monopoly over an idea. I mean, patents are actually a little different. I mean, it's the ability to exclude someone from doing your idea. So it's not patenting code per se. It's patenting a particular idea, a way of doing something, a particular thing. And that can be open sourced. It could be done, it can be kind of, the idea can generate from an open source concept. It can be built through open source code or not. But depending on where those balls fall, you can have a significant problem, especially in an innovative space like yours, where traditionally startup companies are kind of built on their patent portfolios. That one or two initial patents kind of get you that initial funding, get you into the game. In this space, that's not necessarily happening. Regardless, a defensive strategy was mentioned. Some of you may not know what that even means, just as have patents in your portfolio to make sure you don't get sued back. Is that effective all the time? Certainly not. People are certainly trying to do it. We've got a lot of patents out in the field now, applications out in the water. Will those ever be challenged by violating source code, open source licenses? Very little litigation over those licenses. Very little licenses over those licenses. And so where all that falls out, who the different players are, what their strategies are to employ, can very much be in tension with the initial let's just all get along.
Yeah. So you mentioned defensive strategy, and that segues very nicely into something I wanted to talk about. Is James, your company, you mentioned your strategy. Mm-hmm. You've been a pioneer in some really creative ways to manage this issue. And tell us a little bit about that.
Yeah, so it's, I think as Patrick mentioned a short while ago, it's about being realists in that as much as, probably every engineer at my company doesn't like patents, we have to accept the fact that we exist in a world where they exist. And so we had to think of a clever way to address the concerns that exist out there and but also be true to our ideals. And so what we said is, listen, we want to innovate and we want others to freely innovate. Permissionless innovation, as Patrick mentioned, that's important to us. It's a core value of ours and in the Bitcoin ecosystem. So we said, what can we, given those two things that patents exist, but we want permissionless innovation, what is the best way to move forward in this environment? And so we said, well, let's obtain patents over inventions that we think we're entitled to, and that's underway. But let's only do so when we have a framework that's in place, which makes it clear to everybody that we're just obtaining these because we consider ourselves good actors, and we're willing to sort of put as much sort of legal structure as we possibly can around that, and let the world know that in obtaining these patents, that we're doing so to put them sort of in our cupboard so that they're available for everybody to use, and so that people don't have to worry that we'll come at them and use them offensively. Now, by defensive, as Paul was mentioning, it's like the reason we say defensive patent strategy is that to the extent that someone comes at us with a patent, then we are entitled to, we're not going to say we would never use a patent in a court of law. We'd say we'd never use it offensively. We would never try to use it as a weapon of aggression against anybody, but we do reserve the right to the extent that someone were to take a run at us or someone using our technology, that then we could sort of, if the situation allowed or made sense, that we could assert the patent as a countermeasure. And so that's the balance that we struck. It took many conversations internally with our team to make it clear. Patrick and a lawyer on my team, Kat Walsh, who's very experienced in this area, led a couple of workshops, one on the East Coast at Berkman, one on the West Coast at Stanford, where we tried to get as many sort of participants in the ecosystem around the table just to discuss these issues. And then we announced last July what our strategy was, and I think it's fair to say that it was received quite well in the industry. But we need, our hope is that more people are going to sort of adopt that approach, and that's why we're excited about the work that the Perry Annan team are putting together with the IP Council. So,
And how do your developers like this strategy? Thinking they're very happy with it.
Yeah, I mean, again, it was like, there's a lot of idealists in the world, and that includes in the engineering space as well. And we have a very passionate team of engineers, and they've realized that this is the best approach, and we're always that we can think of at least. And just to be clear, the innovation that we put forth last July, I mean, it builds on, just like in software, it builds on earlier innovations. So there was Twitter had the innovator patent agreement. We adopted that. We actually modified it to tighten it up in ways that we felt were better and less sort of loopholes. So we've stood on other people's shoulders in the space as well in sort of creating our framework. And so far, all the reviews, both internally and I think externally, have been quite positive.
Okay, great. So one of the challenges I see for the Blockchain IP Council is we're going to be asking the players to be essentially giving up some rights that they otherwise would have. In many, or we may be asking them that, much as you're doing. You're voluntarily giving up some rights. And I think that is a proposition that startups and even medium-sized companies get, and they see the advantage for them. But does anybody want to chime in on what's the value proposition to the big banks and financial institutions and large technology corporations that are also part of this ecosystem? Any thoughts?
A few.
Okay. Let's hear 'em.
The answer to that question is frankly different at different steps in time and for different types of companies. I mean, the standardization of patents, the openness of patents, the only using them defensively, the fact that you've thought about patents and gotten them, but you don't really want to use them in any particular way is great. It's great for the community that you have, because at bottom, and I think we're really talking about the platform level here, not the middleware or the use case, but really the platform level, is you want people to be using your technology as much as possible. You want it to reach as many people. You don't want to be in the trenches of competing against each other, for each of you having your individual platform and trying to hold each other up to become the market leader that is. You want to work hand in hand to make the biggest, baddest platform or set of small number of platforms for as many people as possible to use. And so as you as a community to come along to say, I'm ready to give up some of my rights to help build that the biggest, baddest platform, will inure to all of your benefits in terms of the scope of the market that you can then capture. And so there are great benefits to that. The challenges begin to mark up when people begin to really start making money off of it. And again, that might be off the platform side, or you've got somebody outside your community. And so I think for the stakeholders and saying, why should I give up my IP rights on the platform level? I think a good margin of you actually will say, yeah, that makes a lot of sense to me, that's fine to do. I think the harder questions come up when, well, how do we, that's great as our little community, how do we prepare for and address folks outside of our community who might try to hold us up?
So,
Can I add to that as well? I think
course you
that there's another element here that distinguishes, say, the startup from the enterprise level company, which is this. Patents historically have been the great leveler, right, in the market. If I'm a startup and I patent my idea, the enterprise, no matter how big they are, has to pay me a toll, right? It's a leveler. So if I am an enterprise size company and I want to innovate in this space, right, I am the one who's potentially most at risk if I don't join arm in arm with the startups who, if those startups are filing patents, are also filing patents as well. Like, we both have a lot to gain on both sides of that equation by saying, if we join together and we say, hey, we all want everybody to use our common infrastructure here, right? Rather than try and duke it out or fight it out in court or something like that. Because it could just very well be that some of these small startups have some fundamental patents that are going to either link up with some of these big enterprises and allow everybody to play on the same platform, or become the method by which those enterprises have to pay rent to whoever owns that patent in the first place. So it cuts both ways.
So you're right, but it has a starting position, and the starting position is that the startups are actually getting patents.
Correct.
And for many, that's a bit of a challenge. I mean, there was a bit of a discussion to be had of, are we going to get patents? Well, we are, but only in very limited circumstances. For many of you, you've just decided open source is the way to go, and I'm not going to get it at all. To get a chip in the game, it may behooves you to reconsider where you're parked on that issue to be able to have that leveler.
And there's a few reasons as a startup that you want to have that conversation early. And again, I can say this from having been an entrepreneur inside a startup and convincing an engineering team, the unenviable task that you had, James, I appreciate it, of convincing them that this is actually a good idea to go file patents that you think are horrible, evil things that you don't believe in, right? I've had those conversations, and it usually goes something like this. We should add some book value to the company, right? We can diffuse them so that the concerns you have that somebody, not us, because we know each other in the company. We're not worried about, I don't think anybody at Blockstream is worried that James is going to become a patent troll, right? What they're worried about is if, God forbid, something happens to Blockstream and they don't execute on their business strategy and they go bankrupt, that a patent troll will come in and buy them as assets and then use them against the community, right? So how do you diffuse those patents? By attaching an encumbrance that lasts beyond the life of the company in the first place, right? We can do that, right? And that's part of the strategy. And the other reason is if you're not even going to use it, if you're not really going to care about its book value, if you're not going to use it offensively, if you're going to encumber it so that no future purchaser would really want to buy it, then what's the point? And a lot of times the point is just to put it out there, right? Just to create what's called prior art. There's no better prior art than a patent application. Once you've filed a patent application with the USPTO, an examiner is going to see, wow, this is an idea that has been documented, right? If somebody else comes in and says, I've got a novel idea, and they try and file the same thing, you've got prior art that blocks them from doing it, right? So it establishes a record, sort of like a blockchain. It establishes a record in time that everybody can see.
right.
Yeah. And to pick up on something Patrick just said at the end there, which is important about a IP strategy, it's not, the prior art and sort of publication is an important part of an overall strategy as well. For those who are of the mindset that, creating a patent thicket isn't to anyone's benefit, this is still a very young space. What we want is to sort of encourage innovation, not stifle it, not have people. There's enough complexity in our ecosystem. Just enormous complexity, including on the regulatory front. Patents are sort of you have to consider like private regulation. You have to worry about that. It's just another thing to worry about, and that's not what you want to be doing. This is hard enough stuff as it is, and so if we can sort of remove that one worry, or at least sort of try to minimize it as much as possible, so that the focus can be on more important matters about innovation, growth, successful business models, those sort of things to create a healthy industry, then we think that's a great outcome. And part of it is just not sort of filing patents, but as Patrick touched on, yes, that is of value from sort of a prior art and publication. It's important from that perspective as well. But I think as part of the IP Council, one of the things I'll be wanting to do there is make sure that we are taking a very holistic view in terms of what we should be doing on the patent front, not just from a sort of a filing strategy and pooling, but also in terms of legislative reform and those sort of things as well.
Yeah. We talk about the tools, and Patrick, you touched on something earlier about the source of patents and examiners possibly not knowing what everybody in this room knows and issuing patents that maybe shouldn't be issued. And that made me think about, maybe we should be educating the examiners. Maybe we ought to start there from the source. What do you guys think?
That is something that when we've held these workshops in the past that has come up is having USPTO days and go in and have a panel of technical experts who helps the examiners understand not just what the technology can do, but where the sources of existing prior art are, right? The idea, and it has to be said, like the idea that a patent examiner is going to go into an IRL chat room or onto a Bitcoin Talk forum post to go search up prior art is just not reality, right? Like that's not going to happen. So educating them on where they can, how the technology works, where they can find prior art, and then potentially creating tools so that we can move some of these discussions into a format that's more accessible for examiners so they can see the actual prior art.
And something also to consider as this body is the mechanisms that you have available in the patent office that you should monitor. I mean, you should be monitoring what applications are going. And as a community, you should be monitoring what's happening in your space and who's doing what and what outsiders, especially what outsiders are doing in your space. And you do have opportunities if you're keeping an eye on things and you're fast enough to actually comment on certain applications that are in the patent office, submit prior art to the examiner to be involved in that process to prevent certain patents from being issued. And once they issue, you also have certain tools at your disposal as a society, as a community, to approach the patent office and get that patent to be re-examined. That might be part of the tools that you have at the end of the day to try to address some of those issues.
Absolutely, and creating like approaches to streamline that process, right? So that people who have prior art can see that a patent was filed over their prior art and have the ability to file it quickly with the examiner who's examining that particular application. The cost, and this is one of those key things, and I completely agree with you, the cost rises over time when it comes to invalidating patents, right? The earlier you catch a bad patent, the cheaper it is to prevent it from actually being approved in the first place. The most expensive way to invalidate a patent is years later with this guy litigating it in court.
Cut that off.
Not good for your business development, I guess.
But he does have a nice watch.
So let's talk about
it. It's the socks. It's all about the
You can
socks.
tell who the litigator's the guy with a nice watch. But yeah, let's talk about that. So let's say we're less than 100% effective in having bad patents get granted, and people like, for example, Craig Wright has filed.
God bless him.
Near 100 patent applications now on, we don't know what they look like yet, but on apparently fundamental aspects of the ecosystem. Are there tools we can use, and somebody who's not going to be a part of this community, are there tools we can use to combat that also?
Limited. Yes. I mean, certainly the answer is yes. I mean, Craig Wright has done some interesting things because it's not in the United States. I mean, the bulk of his patents are in the UK.
Well, not yet.
The applications. We know that there are a lot of applications in the UK.
Right. The year hasn't passed. You can still.
Well, I don't know about what's happening in the US, but we do know that a significant bulk of that is in the UK, which is just off the top of a US patent litigator's head. That's unusual. Especially in this particular space, and the certain rules that are there. In addition to the PTO rules, addressing the examiner, having the ability of kicking a patent back to the office to try to get it re-examined, having a defensive strategy to make sure that if someone sues you, you can sue back, the MAD strategy, mutually assured destruction type strategy. There are other tools that you can use to try to fend off a patent lawsuit, but they're not as exciting and certainly not as successful. Some of them are just plain old insurance policies.
Right.
I mean, there are patent insurance policies out there. For the insurance folks that came up a little earlier, it'd be interesting to hear what those policies now cost. Some of them are not as reasonably priced as one would hope. They are expensive because patent litigation, frankly, is expensive. The publication route is both there's a risk reward there. A lot of you want to get published as quickly as you can to say, we've just got this exciting thing. Let's tell the marketplace all about it because it really is wonderful and we'll get some press out of it. The lawyers in the room are going to say, now, just take a moment. Let's think about our patent process. Let's think about our IP procurement strategies. Do we want to do this now? Do we want to wait? The balance of that, just having those in addition to patents on file, is to have just a lot of material out in the public space that people can turn to try to use as prior art whenever it gets asserted. So lining up some of these strategies, you have some arsenal to defend against the kind of the outliers, the trolls, so to speak. But the reality is they exist. They are very thoughtful. They're very creative and frankly hard to defend against.
Okay. I see we're running short on time. Do we have additional time for questions? Or is that in my 2 minutes? Okay, so are there any questions? I'd like to take a question or two if we have them. Yeah. Is there a microphone? No.
Well, I would agree with that. I think it's premature for standardization in the industry right now. I mean, think about how many different competing consensus algorithms there are. We don't even know which one is going to be the one that takes hold in the marketplace or solves certain problems. And I think there are so many different verticals that could be attacked here that you wonder, standardizing now before we've even identified the actual markets we're going to be addressing seems a bit premature to me at one level. But I think when we're talking about standards in this conversation around IP, it's more about technical standards like reference implementation software and things like that, right? Where the standard is being set by the code that's being implemented. So there's two types of standards. There's standards that are top-down, right? Here's a standards body that says we need to coordinate this industry together to come up with something that makes sense so the marketplace functions properly. And then there's the emergent type of standard, and that's what we're seeing in the open source community. Emergent standards, right? Let's run a bunch of code and let's see what works and what people adopt and use over time. And as winners emerge in the marketplace, we'll describe how those things work. And then you have these descriptive standards that were emergent rather than standards that came from the top and pushed down. There's a place for both of those things. I think it's very premature for top-down standardization because we haven't even identified the markets and the players. But I think we're seeing the process of emergent standards that are starting to slowly be described over time.
No other thoughts?
Second question.
Okay. We have another question? Do we have time for one more? Anybody? No?
All the way at the back.
Oh, we do have another. Okay.
No?
In the back, you tell. Okay, no questions. Okay. All right, well, thank you, gentlemen. Appreciate your time. Thank you all. Thank you.